Whether you wear a badge or not, if you care about courage, clarity, discipline, and the price of decisions in the moment that define lives, you've come to the right place. This is where training meets consequence, where the law collides with human behavior, and the fog of uncertainty tests the limits of reason. These are the stories of pressure, of purpose, and what it means to hold the line when the world loses balance. I'm Don, a police officer, instructor, and founder of Forecast Securities Group, and I'll be your guide through the storm. Welcome to the Conditions Report.
Hi guys, welcome back. This is the Conditions Report, episode 14, and today's show is called Lawful but Awful. I'm Don, and this is the Conditions Report. If you've already been listening to the show, then you know the premise. If you're new here, here's what you need to know. This is the weather forecast for street cops, detectives, and admin. What's coming, what's changing in the environment that we work in. Before we go any further, a quick disclaimer. I am not an attorney, and nothing discussed on this show should be considered legal advice. I'm not speaking on behalf of any government organization or any law enforcement agency, and the views expressed here are those of Forecast Securities Group, and they're an exercise of protected American free speech. If you need legal advice or guidance specific to your agency or jurisdiction, you should consult qualified legal counsel. This podcast is for educational and informational purposes only, and we're not here to judge the actions of officers involved in incidences or to second-guess decisions made with the benefit of hindsight. The point is to learn from their hard-earned lessons on our behalf and improve as a team. Today's episode summary is called Lawful but Awful. That phrase describes a class of outcomes that exist anywhere where people are entrusted to make split-second decisions with little to no insight. In policing, those outcomes are often especially hard to ignore. These are incidences where officers act within constitutional limits, where courts later determine that the use of force did not violate the Fourth Amendment, and where civil liability does not attach. And yet, even after the legal process is finished and the outcome still feels deeply wrong, morally or ethically, even to professionals who understand that use of force decisions are often shaped long before force is ever used. This episode is not about blaming officers for lawful decisions. It's not about rewriting constitutional doctrine or pretending the law requires tactical perfection. It's about understanding the gap between what the law permits and what professionals should demand of ourselves. Before we go any further, it's important to be clear about what this episode will not address. There has been significant public attention on the recent federal agent-involved shooting in Minnesota involving Immigration and Customs Enforcement. That incident is the subject of ongoing investigations and incomplete fact development. And there are already many voices reacting to it in real time. This episode will not analyze or comment on that shooting. Responsible analysis requires settled facts, records, rather than speculation or preliminary reporting. When the investigations are complete, there may be a time to examine that carefully and honestly, but that time is not now. Here's the situation brief. The anchor case for this episode is Voss v. City of Newport Beach. This is a Ninth Circuit case. This case matters because it doesn't begin with a sudden ambush or unavoidable split-second confrontation. It begins where there's time, information, and opportunity, and then collapses into seconds. On the evening of May 29, 2014, Voss entered a convenience store in Newport Beach and began behaving erratically. According to the opinion, he ran through the store and shouted at customers and employees. His conduct alarmed people inside, but the store remained open and occupied. At this point, the incident was chaotic but unresolved. There was volatility, but not yet clearly defined lethal threat. Voss had apparently armed himself with a pair of scissors, and a store employee attempted to intervene and was cut in the hand. Voss shouted that he had a hostage, and though he released the employee shortly after, these facts later became central to the legal analysis because they framed the seriousness of the call. There was a weapon, there was injury, and there was unpredictability, though there was no ongoing assault when officers arrived. Officers responded and cleared civilians from the store. That decision changed the nature of the incident. What began as a public disturbance became a contained law enforcement problem. Officers gathered information from employees and learned that Voss had retreated into a back room and closed the door. This is where time enters the story in a meaningful way. Additional officers would later arrive, patrol vehicles would be positioned to provide cover, officers staged behind open vehicle doors, public address systems were available, less lethal options were present, including 40mm launchers. A K-9 unit was present, and officers were armed with rifles as well. From the outside, the scene was controlled. Civilians were no longer exposed, distance and cover existed, and resources were readily available. Approximately 20 minutes would pass while Voss remained inside this back room, during which time, according to the court record, officers did not communicate with him, no dialogue occurred, no warnings were issued, and no attempt was made to establish verbal contact. And whether that silence was intentional or inadvertent or the product of uncertainty, it's not fully explained in the record. What matters is that silence itself became part of the factual environment. And silence is not neutral. In law enforcement operations, silence is a decision, whether it's acknowledged or not. Time without engagement can stabilize a scene, or it can allow tension to build without direction. Eventually, though, Voss would exit the back room and move rapidly towards officers with an object raised above his head. Officers, believing the object was scissors, as previously reported, would issue commands to drop the weapon. Voss would continue to rush forward, and the distance would be closed quickly. What had been a slow-moving incident would collapse into seconds. Within roughly 8 seconds, officers would fire. Voss collapsed and later died from his injuries. A metal display hook was found near where he fell. Those 8 seconds would become the focus of the lawsuit. Everything before became the context. And it goes to show that these incidences can collapse in seconds, and that while we are under the impression that we have everything under control, sometimes the suspect, or in this case, the mentally ill person, also has a say in the outcome of these events. That brings us to the current conditions. The legal framework governing this case begins with Graham v. Connor. The Supreme Court held that claims of excessive force must be analyzed under the Fourth Amendment's objective reasonableness standard. The court emphasized that reasonableness must be judged from the perspective of a reasonable officer on scene without the benefit of hindsight. Importantly, Graham did not say that everything before the moment of force used would be irrelevant. It said that the ultimate constitutional question must account for the realities officers face, including uncertainty, speed, and danger, and that distinction has been misunderstood for decades. And the Supreme Court addressed this misunderstanding more directly in Barnes v. Felix. In Barnes, the court rejected the idea that the court may artificially isolate or narrowly slice sections of time immediately surrounding the use of force, then ignore everything that came before it. The lower court had evaluated the shooting by focusing almost exclusively on the final moments, treating earlier actions by officers as legally irrelevant. And the Supreme Court held that this approach was wrong. The court clarified that the Fourth Amendment requires consideration of the totality of circumstances, and that there are no temporal cutoffs that allow courts to disregard pre-force conduct simply because the force has begun. Events leading up to the use of force are part of the same encounter and may inform whether the officer's actions were objectively reasonable. At the same time, though, Barnes did not create a new rule of liability. The court did not hold that poor tactics, bad planning, or questionable upstream decisions automatically render a later use of force unconstitutional. Instead, it just reaffirmed that pre-force conduct is a relevant context, not independent constitutional violation. The legal inquiry remains whether, considering the full sequence of events, the force used crossed a constitutional boundary. This clarification matters in cases like Voss. The court would have been permitted to consider the officer's silence, their use of time, their positioning, and the availability of alternatives as part of the totality of circumstances. But those facts would not have controlled the outcome. They inform the analysis without replacing the core question of objective reasonableness at the moment force is used. Barnes makes it clear that courts cannot pretend the lead-up doesn't exist, but it does not make the lead-up dispositive. That distinction preserves the constitutional floor while acknowledging reality. That clarification frames cases like Voss. When the Ninth Circuit explained that a Fourth Amendment violation cannot be established merely because officers employ bad tactics that result in a deadly confrontation that might have been avoided. It was reinstating settled law. That boundary is illustrated in cases like Billington v. Smith. In Billington, officers shot and killed a suspect after making a series of tactical decisions that were later criticized. The plaintiffs argued that those poor tactics should render the shooting unconstitutional. The Ninth Circuit, though, rejected those arguments. The court held that even if officers exercise poor judgment earlier, those mistakes do not automatically make the final use of deadly force unreasonable. The constitutional question remained focused on whether the officers reasonably perceived an imminent threat at the moment force was used. The Supreme Court confronted similar arguments in City and County of San Francisco v. Sheehan, but in a narrower way than is often described. In Sheehan, officers entered a confined room and encountered a mentally ill woman armed with a knife. After the shooting, critics argued that officers should have waited longer, disengaged, or employed different tactics tailored to her mental health condition. The Supreme Court did not decide whether those officers' conduct violated the Fourth Amendment. Instead, it resolved the case on qualified immunity grounds, holding that at the time, no clearly established law required officers to delay entry or adopt alternative tactics in that situation. In doing so, the court reaffirmed a foundational point of the Fourth Amendment doctrine. The Constitution does not mandate optimal tactics or require officers to select the least intrusive option available. The inquiry remains whether the force used was objectively reasonable in the light of the threat officers were confronted with. At the same time, though, courts have been clear that pre-shooting conduct does not vanish from analysis. Ninth Circuit addressed that balance in Hung Lam v. City of San Jose. In Hung Lam, the court explained that an officer's actions leading up to the use of force are part of the totality of circumstances. Tactical decisions, communication, positioning, and timing help explain what the officer perceived and why the encounter unfolded as it did. But those considerations do not independently establish a Fourth Amendment violation. They inform a reasonableness analysis without replacing it. The constitutional question remains whether, considering the entire sequence of events, the force itself crossed a constitutional boundary. And that's how those principles operate in cases like Voss v. City of Newport Beach. And the Ninth Circuit did not ignore the officers' pre-shooting conduct. It expressly acknowledged that officers had significant time on scene to access cover, multiple officers, less lethal options, and that there were prolonged periods in which no communication with Voss occurred. The court also recognized that a reasonable jury could conclude that a different tactical decision might have altered how the encounter unfolded and might have reduced the risk of a deadly outcome. Critically, the court did not hold that those circumstances were irrelevant. Instead, it treated them as part of the totality of circumstances, informing the reasonableness analysis. At the same time, the court refused to treat those upstream decisions as independently dispositive of the Fourth Amendment. The constitutional inquiry remained focused on whether, at the moment, Voss advanced towards officers with an object raised above his head and the use of deadly force was objectively reasonable. Applying this framework, the Ninth Circuit held that although a reasonable jury could find a Fourth Amendment violation, the officers were nonetheless entitled to qualified immunity because existing precedent did not clearly establish beyond debate that their conduct under those specific circumstances were unconstitutional. In other words, the courts distinguished between what might be unreasonable as a matter of fact and what was clearly established as unlawful as a matter of law. The constitutional analysis ended there, even though the case itself did not. The LNA for this week comes from Aristotle. We are what we repeatedly do. Excellence, then, is not an act, but a habit. This principle belongs here because this episode is about that space between what the law permits and what professionals produce. Courts ask whether force crossed a constitutional boundary. They may discuss tactics, training, communication, and pre-shooting decisions as part of the totality of circumstances. But those conditions and considerations do not set a standard. They provide context. The decision still turns on objective reasonableness, and that limitation is deliberate. Constitutional law is not designed to enforce competence. It's designed to prevent the abuse of power. And when a court concludes that force was lawful, it has not said in the same breath The encounter was well managed, and it has not said the outcome was optimal. It has not said the organization performed well, and it has only said that the Constitution was not violated. And this is where professional responsibility begins. Policing is a profession built on reliance. The public relies on officers to manage risk competently under stress. Officers rely on training when time compresses and judgment narrows. Agencies rely on systems to produce consistent performance across people and years. And in that environment, competence is an ethical obligation. Bad tactics are not ethically neutral. When avoidable, deficiencies in preparation, communication, or tempo are repeated, and when those deficiencies predictably place people at risk, the issue is no longer legal. It's professional. People rely on us to know what we're doing. Excellence is not what we say, it's what we repeatedly do. And leadership is responsible for what an organization repeatedly produces. We owe a duty to each other and to the community to train mentally and physically and to develop our craft to be true professionals we claim to be. Brings us to the extended forecast. Voss is not a warning shot from the courts. It's just a reminder of where the courts stop. The constitutional framework is stable, and courts will continue to enforce the floor, not the ceiling. They will continue to reject attempts to convert tactical critiques into Fourth Amendment liability. And they will continue to ask whether force was objectively reasonable when it was used, informed by context, but not dictated by it. And that's not going to change. What is changing is where judgment concentrates once the legal questions are answered. We now operate in an environment where nearly every use of force is captured entirely on video. Body-worn cameras, surveillance systems, cell phones, and bystander footage means that encounters are no longer reconstructed primarily through testimony or reports. They are replayed, slowed down, paused, zoomed in, and circulated often within hours. And the reality has fundamentally altered how force is evaluated outside the courtroom. The court of public opinion does not apply a Fourth Amendment standard. It doesn't apply qualified immunity, and it doesn't limit itself to the moment force was used. It evaluates the entire encounter as a continuous narrative. It asks why officers were there, how they spoke, how long they waited, whether alternatives appeared to be available, and whether the outcome seemed inevitable or avoidable. Those questions are not legally dispositive, but they are reputationally decisive. It matters because policing does not operate on legal outcomes alone. Trust, legitimacy, and institutional credibility are shaped by what people see, not by what judges later write. An incident can be lawful and still permanently damage an agency's standing with its community, its elected officials, and its own workforce. This is where the gap tends to widen. When a court finds force lawful, the legal system is finished. When the video circulates, the professional consequences often begin. Administrative investigations, internal reviews, training audits, policy revisions, and leadership accountability frequently follow, not because the law demands them, but because the public confidence does. Officers and agencies should expect that upstream decisions will receive increasing scrutiny. And in this environment, silence, delay, posture, positioning, and communication are no longer invisible precursors to force. They are part of a visible record. They shape how force is understood, regardless of how it is legally classified. For the line level officer, this means lawful force will not automatically end a conversation. Video has compressed the distance between action and judgment. Decisions made in minutes earlier now appear inseparable from decisions made in the final seconds. For supervisors, this means scene ownership carries reputational weight as well as legal consequences. The tempo, coordination, and engagement decisions are no longer internal considerations. They are observable behaviors that will be evaluated by audiences far outside the profession. For agencies, this means training that focuses narrowly on legal thresholds without addressing how encounters unfold on camera will increasingly fall short. Organizations will be judged by what their officers in training make visible, not by what their policies technically allow. Cases like Voss do not expand constitutional liability. They identify the minimum, but beyond that minimum, policing now operates under constant observation. The profession is being evaluated not only on whether force is lawful, but on whether it looked necessary, measured, and competently managed. That evaluation is not a fair one. It's not always informed and it's not legally precise, but it is the reality we work in. Lawfulness will still be the standard. It will not be sufficient, though, to satisfy the public's desire for professional, competent police. And that is the weather pattern moving forward. As we close, let's remember the point of this show isn't to pass judgment or to revisit decisions with the benefit of hindsight. It's to learn as a team and improve. And we're all leaders. The work is complicated, the environment is demanding, and none of us get it perfect. I'm Don, and this has been the Conditions Report. Be the calm in the storm, the clarity in confusion, and always influence the weather. See you next week.